no matter what, having a will is going to be better than not having a will. You are making life significantly easier for the people that have to pick up the pieces when you're gone. If you have everything as buttoned up as you can.
Welcome to Wiser Retirement Podcast. Are you curious about what happens if you die without a will? We get that question a lot. I'm Shauna Theriel, and today I'm joined by estate planning attorney Arun Gupta. Each week, we bring you practical advice on retirement, investing, and planning for your financial future. Don't forget to subscribe to the podcast wherever you're listening. Let's get started. I am so excited to have you here today.
I'm excited too.
How you doing?
I am doing great.
It's your first episode with us.
Yes, it is.
Yeah. So you and I have known each other for, I don't know, since 2012, 13 years.
Going on 13.
So I have to tell you, and I don't even know if I've told you this. I think I have, but you have been instrumental. So estate planning is one of the things that is near and dear to my heart. I learned really early in my career how important like tax and estates were, because everyone could do planning and cash flow and all that. But the taxes I didn't understand, specifically estate taxes, but then getting into the estate planning, I realized how important it was, because I kept seeing like so many people's estates that, you know, were not set up properly. And enter in Arun, where, you know, we've worked together with clients for years, and you have been instrumental in actually teaching me so much about estate planning.
Well, I appreciate that very much. Estate planning, financial planning, they go hand in hand. So it's always good to make sure even if you're a financial planner, it's still good to keep up, with what's going on in estate planning. Same thing, practically speaking, with estate planning and the law, you can set your estate planning documents up for a client, but then if they don't have that in sync with their financial planner, sometimes it can run into an issue. And
that's what I've seen. It's like so many, and this is not a slap at anybody, but I've seen so many planners just refer you out to someone to do estate planning attorney, and then that's it. But then it's like, they don't know the balance sheet. They don't know the client nuances. And so what you and I have done, along with other advisors, is really sit in the room with you and the client, if the client's okay with that, of course, and then go through like, here's where their assets are, here's where it should be titled. Because so many times, and I've talked about this before, we have a client come in and it's like, oh, well, my will's good and everything's good, but all of their assets are in retirement accounts. And it's like, it's not even going through the will. So, and that's just like a little snippet, but you and I have sat through, I don't even know, hundreds of meetings together. Yeah. And then behind the scenes,
hours and hours of just, we've beaten some topics to death, spinning around in circles, but that's what keeps you sharp,
I love it. So this working relationship has always been near and dear to my heart.
Well,
so I'm so glad that you're here.
Me too. I'm happy to be here.
Sincerely. And so we're going to talk about today just wills in general. We're probably going to do a different series as well, leading up to several different topics with you, which I appreciate you doing because it's so important. And, a lot of clients, will say, well, I don't even have like a lot of assets. I don't need estate planning. It sounds like it's for like the ultra wealthy, which is not even true. And so really, if you wouldn't mind just walking through what is a will and why is it important, Arun?
Sure. Well, a will, is a document that controls how your assets are going to be distributed upon your death. It's words on paper until you die. Once you die, assets that either don't have a beneficiary designation, or if they are not titled jointly, more often than not, they will need to be probated. What that means is your will be submitted to a probate court. Whoever is designated as your executor will petition the court, provide them with the will, and then that gets the process going.
Yeah.
So basically, it says, when I die, this is how I want where I want all my stuff to go.
Yeah.
And then it appoints the people you want to handle that.
Yeah. And so the things in a will, obviously who the executor is, where the assets go. The other thing that people don't think about when they're like, I don't really need a will, I don't have that many assets. Well, first of all, a lot of your assets could be in like life insurance when you're younger, right? Because we talk about having those life insurance policies. You may have more assets than you think if you pass away, but it also tells who's the guardian of your children.
Yes.
Who controls the assets if something happens to you or both of you. Those things are very important, or else the courts are going to decide.
Yeah, it's always, no matter what, having a will is going to be better than not having a will. You are making life significantly easier for the people that have to pick up the pieces when you're gone. If you have everything as buttoned up as you can,
Yeah.
it's your money. You're the one that decides what you want to do with it. But just because you don't want things to be complicated, or you think you may not have that much, you may actually be making life a lot harder for the people that are, that have to pick up the pieces.
Yeah. And like usually, you're grieving a loss of someone and then having
Hmm.
to do that. Now,
Hmm.
probate in Georgia, you've taught
Hmm.
me is fairly
Hmm.
easy. Like other like Florida, obviously,
Hmm.
a lot of
Hmm.
people don't probate in Florida just because
Yeah.
it's hard, but probate in Georgia is pretty easy.
Relative to other states, it is more straightforward. The probate process is, so there's a probate court in each county. Um, uh, when you die, if your assets are required to go through probate in order for them to be distributed, you have to go through the probate court. You have to submit your will to a probate court. The probate fees, it really just depends on the complexity of your state, the attorney that you use. A lot of these factors go into what it would end up costing. And in Georgia, the probate fees aren't as bad as they are in other states like Florida and New York, California. So you'll often see people try to avoid probate in those states more than you would in Georgia. But you
Still.
still want, if you can avoid it, that's always something that should at least be discussed. It's not the end of the world if you have to probate by any means.
Right.
But more often than not, if you don't have to deal with it, it's probably going to be better.
Well, and that's like a totally different thing than, okay, if you have a will and you probate the will,
Hmm.
but what happens in Georgia if you don't, or anywhere if you
Hmm.
don't have a
Hmm.
will? What kind of mess are you leaving, or what happens in that regard?
So if you have assets that are required to go through probate in order to be distributed, and you don't have a will, it's going to depend on the intestacy laws of the state you live in. So in Georgia, if you die without a will, your assets will be distributed pursuant to, it depends on what your family situation is like. So if you are married and you have no children, then those assets will default to your spouse. All of it,
100%.
100% if you have no children.
Okay. So you said one thing. I just want to back up. So you said if it's going to go through probate. And so
Yes.
that's the key.
Yes.
And I just want to touch on that and then go through like the different families. So meaning if it's joint tenants with rights of survivorship,
Mhm.
it passes to the surviving tenant.
Correct.
If you have retirement accounts, IRAs, 401ks that have a beneficiary designation, it goes to the beneficiary.
That's right.
If you have life insurance that has a beneficiary, it goes to the beneficiary. So
That's
we're
right.
really talking about assets that have no beneficiary
Mhm.
that are not automatically left to somebody else.
That's right.
But even if you are married, but you have like this random account or just a purposeful
Mhm.
account that's just in your name, a brokerage account, a
Mhm.
bank account,
Mhm.
that would have to go through
That's right.
the probate process, whether you have a will or not.
Correct.
And so if you have a will, that's better. But
Mhm.
if you don't have a will, then this is how it's going to pass. But there's a
Correct.
lot of families that don't have anything
Oh,
in place.
Yes, tons.
And so what happens to those families? It depends, like you said, on the state and the families. The stuff that can pass that has beneficiaries would, but what about the stuff that doesn't?
Yeah. So, in that example that I gave, spouse, no children, that's
Right.
more straightforward. Odds are it's probably the way that person wanted them to go anyway. Not always the case. But when you have children, that's when things can get a little bit tricky. So if I'll give you an example. You're married, you have one child, okay? Then the spouse and the child are going to split everything equally. Now, if that child is under 18,
50-50.
yes. So spouse and children will split equally. However,
So I have a life insurance policy. It's $1 million
Mhm.
and I didn't put a beneficiary.
yes,
So my spouse is going to get 500,000 and my child is going to get 500,000.
yes. And you brought up a good point. So life insurance policies, most of the time when you set up a life insurance policy, you're gonna list your beneficiary. But for whatever reason, let's say you just forgot to do it, or you just never got around to doing it. Then in that case, because there's no beneficiary listed, the policyholder, they will make out the proceeds to the estate of whoever passed away, and you can't have an estate account without getting a certificate from a probate court saying this estate has been administered. So if you have a will, That will goes through probate, and the executor gets what's called letters testamentary, which is basically
Mm-hmm.
a certificate that allows them to distribute assets pursuant to the will. If you don't have a will, then there's a few other types of probate, but generally it would be you're petitioning for letters of administration. Same thing, you get that certificate, but then you're obligated to distribute assets pursuant to whatever those states' laws are. Now, if you have,
Meaning, even if I'm the spouse and we have a child,
mhm,
I still have to, as the executor, split that life insurance 50-50 because that's what the state says.
that's right. Now, if you have three children and one married, three children, it's the spouse gets a minimum of one third. So it's
One
equal at
third?
one third.
I
The
thought it was
spouse will,
one half. It's
it's
one
one,
third.
the spouse will get a minimum of one third. So then
Okay.
all the other three children would split the other two thirds.
Wow.
Now, if your kids are over 18, that at least makes it a little bit easier. But if they're under 18, this is when things can get pretty messy.
So you're saying if you have a spouse and three children, I love
Mhm,
this. This
mhm,
is what I'm talking
mhm,
about. And you don't have a will, or you didn't leave you didn't leave a will, you didn't leave a beneficiary for
mhm,
this, then your spouse could potentially just get one
mhm.
third and the other three get two thirds. And they're supposed to support these kiddos.
So this is yes. So technically, the spouse has a conflict of interest with the children. So it's not like the spouse can just say, "Okay, I'm gonna the two thirds that the children are gonna split. I'm just gonna take care of that on their behalf." Look, that's not how it works, because technically there's a conflict of interest between the spouse and the children, and then there's a process where the court has to appoint a guardian ad litem. But we can go on and on about this. But
Wow.
basically, it's a headache, even if everything ends up in the right
Well,
place.
and financially hard.
Yeah, it's a lot. It's a lot to deal with. A lot to deal with. And if you had a will, I mean, it makes things significantly easier. Maybe you would want your most of the time married couples
Yeah.
with kids would leave everything to the spouse if living, if not equally to the children. But that's not always the case,
Well, could have a
especially if it's a
second
second
marriage.
marriage.
Hmm.
There's a lot of different situations which would cause you to examine how you want everything to be distributed. And that's why it's good to have a will, because it makes things uh, very clear. And they don't have to be complicated. The will doesn't have to have fancy tax planning provisions. I mean, it certainly can, but if you just wanted to say, listen, my spouse gets everything, and if my spouse isn't living, my children get everything. If it has all the other requirements that a will needs, witnessed, and an affidavit that is notarized, and the witnesses sign it, it's all going to get to the right place. So it's important to not only have a will, but also make sure that that will is executed with the formalities that are required.
Mm,
They're not complicated, but it's you got to have that too.
yeah. Yeah.
Quick check in. Have you thought about the legacy you'll leave behind? Download 7 Steps to Leave a Financial Legacy, a free guide from Wiser Wealth Management to learn more. It's not just about wealth, it's about leaving a lasting impact. Go to wiserinvestor.com/guides to download your free guide today. Now let's jump back into the episode.
So you mentioned a good thing. We get this question a lot. Can I just, create my own will or do it online or
So I mean, yes and no. So if you wanted to, go on Google and say, will template, whatever yes, you are going to be able to find things that will, at the very least, it's a starting point.
yeah.
But I wouldn't just find the first thing, print it off, and get it signed and witnessed. I would recommend that an attorney at least review something that you prepare. And if you don't want to go that route, give it some thought. At least read everything that it says. Make sure that it has all of the standard provisions. And nowadays with AI, it's getting a lot easier to kind of do things on your own. Which again, it's a good thing, I
Yeah.
think. But
Yeah.
you got to be careful with it,
Yeah.
because there are some formalities that need to be addressed, and sometimes AI gets things wrong too.
Yeah.
So,
Yeah. No, and there's other documents that go along with estate planning, and
mhm,
there's powers of attorney,
mhm, mhm,
healthcare power of attorney,
mhm,
financial power of attorney. There's other things, maybe some trust, which we're going to get at some point,
mhm,
do a whole nother show
mhm,
on trust probably. But some of the things that you just don't think about I'll never forget. I had this client situation where, it was one of those where it's like, okay, it was a second marriage, which we see that a lot
Mm-hmm.
now, unfortunately. The
Mm-hmm.
divorce
Mm-hmm.
rate is fairly high.
Mm-hmm.
And so you may have children from previous marriages and you don't want to disinherit your family, and it's unintended, really.
Mm-hmm.
So, I've seen a situation where a client was like, okay, my will is so good. It sets up a trust and it leaves everything to my spouse, and then for him or her to use during their lifetime, and then once they pass,
Mm-hmm.
then it goes to the children how we want it to go, so
Mm-hmm.
that way it's in trust and they can't redirect the assets or unintentionally, give it, leave everything to your new spouse, and then
Mm-hmm.
maybe they direct it just to their children, that
Mm-hmm.
kind of thing. Like,
Mm-hmm.
you would hope people wouldn't do that, but sometimes when money's involved, they do. And maybe it's not just very clear, as unintended. So then this individual had everything. I mean, the documents were
Mm-hmm.
great, but guess what? All of the accounts were titled joint tenants
Yeah.
with rights of
Mm-hmm.
survivorship.
Mm-hmm.
And I'm like, it's not even going in the trust.
Yeah.
Because what happens there, it's like, okay, this is great that you have this piece of paper and this document, and this was very thoughtfully
Mm-hmm.
put into place,
Mm-hmm.
but your IRAs are all being left to her,
Mm-hmm.
and all the brokerage accounts are joint tenants with rights of survivorship. So there's nothing going in that trust when you pass.
Yeah, you have to make sure that, once the document is signed, the next step, whether you have a trust or you don't have a trust, you need to make sure that your assets are flowing the way you want them to flow.
Right.
Sometimes maybe you want that IRA just to go to your spouse, and you want everything else to go to the spouse and the kids. You got to make sure you know how everything is titled. Again, most accounts that are titled jointly have right of survivorship provisions, so it's going to default to whoever's the survivor. There are some financial accounts that you can have as tenants in common, basically, where it's treated as 50-50, and when one person passes away, their 50% goes through however whatever their will says. And with real estate, same thing, except I'll run into this problem a lot. Spouses have a home that they think is titled jointly, and it is titled jointly, except it's not titled jointly with survivorship provisions.
Is there like a default in Georgia?
So if you don't include survivorship language in that deed, if it just says that they own it jointly,
tenants.
the default is tenants in common,
Wow.
not survivorship, which creates an issue, especially with, deeds from the 90s now, I guess it's old 90s, 80s, 70s.
That's funny.
Where you'll just see the tenants in common, or it's a simple deed and it just doesn't have the survivorship provisions. And if that's the one asset that needs to go through probate, because everything else had the survivorship provisions, or they had beneficiaries, but the house, it would have to go through probate in order for title to clear to that other spouse, or however the person has those assets being distributed in their will. So again, it's annoying, obviously, to have to go through this, and that's why it's good to check if you've got a financial planner, financial advisor. Talk to them. They'll take a look at it. You just got to let them know. They'll do the dirty work for you. Oftentimes, that's what we do behind the scenes.
Yeah.
Clients, this is not fun stuff to think about. What happens when I die? It's hard. It's painful.
It is.
A lot of times, if you have attorneys, financial planners, tell them what you want. They can work behind the scenes,
Yes.
work together, and deliver something to you that's it's easier to digest.
Well, that's what I always love. That's this collaboration,
Mhm.
because that's exactly what we say.
Mhm.
It's like, well, how do you just take all the minutia? If you were to pass,
Mhm.
what do you want to happen?
Mhm.
If you were to you were to pass, what do you want to happen? You're both to pass, what do
Mhm.
you want to happen? And it's a hard conversation
Mhm.
sometimes.
Mhm.
Either they bring us in then, or maybe they talk about it first. But then it's like, okay, if we're starting with the end in mind,
Mhm.
knowing we can work backwards and say, okay, well, this is what this looks like, and then apply that. So, okay, if you pass first, it does this, and you pass
Mhm.
first, it goes this. And then if you both pass, this is how much each person will actually get. Are you leaving enough for your spouse? Are you leaving, and are you
Mhm.
leaving, are you leaving it how you intended to do it? So that way they can actually visualize or see it or think about it in those terms, instead of just saying, here's your assets, here's your documents. And it's
Mhm.
not really, there's no cohesiveness.
Yeah, no, as we collaborate, if you have a business, or if your tax situation's complicated, we'll then loop the CPA into
Exactly.
a collaborative effort. I think is beneficial for all.
Some other questions we get. This is a good question, actually. What if you pass away with a lot of debt and there is no will?
Okay, so if you have a lot of debt, um, so when you die, before your assets are distributed to your beneficiaries, your debts have to be paid. So
Is
in
that true
addition
of like
to,
retirement assets too?
so
Okay.
not it depends on how they flow. Now,
Okay.
if you didn't have a designation on your retirement account and it defaults to the estate, well then yes, that's part of the pie. Now, if not, if it just goes to that beneficiary, then that's not part of the debt. So
Okay.
but your other assets would be.
Got it.
And if an estate has more debts than assets, then there's a certain order of the
Mm,
who gets what. But basically, all the all the people that you owe money to, they're going to get paid a percentage of what
first
they owed first.
percentage.
Before and at that point, if there's more debts than assets, there's really
It's
nothing left for
insolvent.
them. Now, again, those assets are probate assets, right? Not if you have a beneficiary on a retirement account or your 401k, that's separate. Life insurance proceeds, that's separate. If you've got the beneficiaries on them.
Interesting.
Yes.
Interesting.
But when someone dies and there is a debt, I will say that it, no debt collector is none of it's an enjoyable experience, but they know that the chances of getting their full payments less when someone passes away, so you can negotiate those down at least.
Mm.
Still, it's not fun to deal with. You want you want this addressed before you pass away, if possible. But again, if we knew when we were going to die, this would all be a lot simpler.
Right. We could do
Yes.
perfect planning if we knew exactly when you were going to pass
yes,
away, which
yes.
I don't even know if I'd want to know that. That's just
Yes,
like, no.
yes.
So another question we get, this is a good question. So we always say, like, looking at your wills and your estate planning, the documents in the state in which you live, and you referenced that a couple times.
Mhm,
So if you move,
mhm.
does that mean that those documents are not in force any longer?
So generally speaking, no. Usually, as long as your will was validly executed in the state that you lived in when you lived there, they will generally honor that. And if there's some different state provisions, there's different default scenarios. But generally speaking, if you have a will in Georgia and then you move to another state and you die a month later without having done a new will, your old will, generally speaking,
What
its
about 3
provisions are going
years
to be
later?
same thing. Generally
Okay.
speaking, as long as it was validly executed, it's going to be okay. Now, it's still a good idea if you move out of state. Always a good idea. Check with the licensed attorney in that state and see what, if anything, needs to be updated. Power of attorney documents, healthcare directives. Different
Yeah.
states have different rules, so it's always a good idea to at least check in. But don't think that just because you move out of state, you have to do a complete overhaul and every single little thing needs to be changed. That's not necessarily the case. Sometimes you may only need to update one or two things, or if you have a trust, you don't need to update anything at all. Really, it really just all depends.
Which is really what, I know
Mhm.
over the years, I don't want to say evolve, but things we've been doing have been
Mhm.
changing. Maybe evolve is the right word.
Yeah, I think so.
Using a revocable living trust for a lot of
Mhm.
things, which we're going to do a show on that too
Mhm.
coming
Mhm.
up here. I think it'll be really helpful because we get that question a lot. But that's what you're referencing is
Yes.
basically,
Yes.
having that in place of, you still have a will, but it's kind of
Mhm.
like that is really the direction
Correct.
that the estate goes is based on what the revocable living trust says. kind of
Correct.
thing. Yeah.
Correct. That's right. And we've talked about probate and submitting your will to a court and getting appointed. All of that. One of the reasons people do trusts is so none of that matters. There's a lot that goes into it, but as you said, from my experience, I'm doing more trusts for clients now than I used to. That's a combination of a few things. One, as I've spoken with more financial advisors and I'm more in sync with their planners and their CPAs, it can be easier to do a trust for them and they
Yeah.
prefer it. That plus probate courts in the big counties here, Cobb, Fulton, DeKalb, they're growing counties. Courts are understaffed. The probate process, even though it's not as bad as it is in other states, it's still not fun to deal with. So
Yeah.
I am seeing clients use trust more and more, but you don't have to do a trust. I don't want people to think, oh, I
You need a
have to do a
trust.
trust. I have to. You don't have to. It might not be right for you. It may be easier and simpler to just say, I've got a will and it's going to take care of everything that I need. I don't need to do any more legwork besides this. It
Right.
really all depends.
Right. Absolutely. Um, so we'll talk about trust and another one that will be really, really helpful. Um, And I truly, the other one I wanted to ask you, we get this question a lot. So when you're married, again, I'm not always trying to reference
Mhm.
divorce,
Mhm.
but when you're married and it says, a married person and you names your spouse, et
Mhm.
cetera,
Mhm.
or if you're not married and you get married, what happens when you change from marriage to divorce or vice versa and your
Good question.
documents one way or the other?
Good question. So in Georgia, if you've got a will and you name the will says, if I die, my spouse gets everything. At the death of the spouse, my kids get everything. And then you get divorced, you never get around to updating your will. Your spouse is going to be treated, your ex-spouse is going to be treated as if they were deceased. And
Mm.
basically they're cut out. And so your kids would get everything if you died. Now that's for a will. Now that's not always the case with retirement accounts with
That's
their
definitely not the
designations,
case with
IRAs, 401ks.
beneficiaries.
Yes, those I'm not going to say if you get divorced and everything is going to go to your kids anyway, don't update your will. I'm not definitely not saying to do that, but at least the probate assets would go to your kids.
Interesting.
But your retirement account, that's a different
Yeah, if you
story.
don't change those,
Yeah, I mean, certain custodians may have different rules, and but generally speaking, no matter what, if you get divorced, that is a signal. Hey, I need to check up on my estate planning documents, my retirement account designations, basically everything. You want to make sure that is in line with what you want. Big life events, divorce, having children, you win on the lottery. All of these things are signals that, hey, maybe this could affect the way everything is designed.
and make sure you set your eyes on them too. Because I've seen, in client meetings, we're meeting with people, and it's like, oh, I know my beneficiaries are correct on my life insurance, my 401k, and
Hmm.
I'm like, well, let's log in and look.
Hmm.
And they have their laptops. We
Hmm.
like to do working meetings with
Hmm.
our clients, and they
Hmm.
log in and they're like, oh, I never updated it.
No,
So
I
like,
mean,
actually put your eyes on it. I've seen that
of
so
course,
much that it's
yes.
not updated, or if you get
Or you thought you
married,
did.
yeah,
I don't remember
exactly.
what when the date and it's a thing you thought you did sometimes. If you
Right.
had it open on your browser, maybe you just went to bed without clicking it and you just thought you did, and it's
Right.
so easy, but it's also so easy to miss.
Absolutely. This can really be an overwhelming process to set up estate
Hmm.
planning, and we try
Hmm.
to make it as easy as we
Hmm.
can for our
Hmm.
clients.
Hmm.
And it is something, like you said, that is so uncomfortable to talk
Hmm.
about, but it
Hmm.
really is necessary. And it
Hmm.
doesn't really matter how many assets you have.
Yes.
It's really just, and some people are like, well, I don't have any kids. I don't have a spouse. I don't need to do anything. But still, if you lose your sister or, another family member, and you're trying to pick up the pieces, like
Hmm.
you mentioned, that
Hmm.
can still be really
Hmm.
hard. So just, I guess if anything out of this, today we've learned, make sure that at least your beneficiaries are
Yes.
updated.
Yes.
Make sure that you at least address having a will or
Hmm.
something.
Hmm.
There's just so many components with the guardian and,
Hmm.
who you want to handle the money, because
Hmm.
the courts will decide if you don't.
Yeah, I usually will tell people the biggest, if you don't have a will, the biggest reason to have a will is once you have children. That is the signal to me to, hey, I need to have this in place, because if I don't, something happens, you're creating a massive headache for many people. If you don't have kids and you're married and you want everything to go to your spouse, that'll happen if you don't have a will. Unless you've got other beneficiaries for previous accounts, and depending on
Right.
what those custodians' rules are. In any event, it's good to just have things in place, or at least have that conversation.
Yeah.
Because, and even if you've got a hard time making a decision as to, I don't know how much to give this person or that, I can assure you, having something is better than having nothing in place. And these documents can be updated whenever you want. If
Yeah.
there's just a simple change you want to make, it's called a codicil to your will. It's not time consuming if you just want to change, who you want your executor to be or whatever it is. And if you want many changes, well, then it's probably easier to just do a brand new will. It's always if nothing happens in your life that's a big event, then I'd say every 3 to 5 years, just take a look at your documents
Yeah.
and make sure that everything's in place.
Oh, thank you so, Irene. I'm so glad you were here. I'm so glad.
No, I appreciate being here, and I'm looking forward to many more conversations about estate planning and how it relates to your
Absolutely.
finances.
Absolutely. We'll have you back on for sure. And obviously we'll continue working together. And truly, I'm appreciative of everything you always teach me. I even learned, I thought it was 1/2 for some reason. And it's 1/3. That's a huge difference than I was saying. But so I appreciate you. And I
No,
always
of course.
say, I'm not an attorney. I just know enough to be dangerous, but here's what I think it is, but let's go to the expert, obviously.
No, it's honestly, not all financial planners have the estate planning knowledge that Shauna does. It is very important. I think more financial planners would, I think they do themselves a favor by just brushing up on this stuff because it's so relevant.
Yeah. Well, thank you so much. I appreciate you being here. Thanks for listening to today's episode. If you're interested in learning more about Wiser Wealth Management or want to schedule a consultation to meet with one of our fiduciary financial advisors, you can do so by going to wiserinvestor.com, or you can click on the link in the episode notes. See you next week.
Thanks for listening to a Wiser Retirement podcast. We hope you enjoyed today's episode. Make sure to subscribe wherever you're listening. That way you don't miss any new episodes. We'd also appreciate if you could leave a rating and review. If you have any questions about anything that was discussed today, head to wiserinvestor.com and reach out. This podcast is strictly for informational purposes only and is not to be considered as investment advice or solicitation to buy or sell any financial products, securities, digital assets, or any other investment vehicles, or a basis to make any financial decisions. Wiser Wealth Management Incorporated is a registered investor advisor with the SEC. The host and/or guests may personally own securities, digital assets, or other investment vehicles mentioned on this podcast. Neither the host nor guests of the show are compensated for their participation, and no referral fees are paid to or received by any host or guest for clients, listeners, or similar interests. Investments involve risk, and unless otherwise stated, are not guaranteed. Be sure to first consult with a qualified financial advisor, tax professional, insurance professional, and/or legal professional before implementing any strategy discussed herein. Past performance is not indicative of future performance.